Now we've read in the newspapers incidents of mob lynching, where you have a group of people who's incited or excited and commits the offense of murder. Now, when this group commits an offense of murder, it was debatable whether all the members of the group, not just the person who assaults the victim, but whether all the members of the group could be punished under section 302. For all the members of that group to be punished under section 302, the prosecuting agency had to establish what is called as a common intention, which means that all the members of the group, not just the person who's assaulting the victim, but all those who participated in that assembly and charged, had the common intention of committing the murder of the victim. Now, to establish common intention is a tall order. I may participate in a mob, and my intention may not be to kill the person. My intention may be to possibly agitate, at times physically, against that person. But as a result of that, the person dies. Now, can I be accused of committing an offense of murder? Debatable. But because we had been seeing the occurrence or recurrence of these offenses, of this crime, it was thought that it should be made into a crime by itself. So now in that light, let's read clause 2 of clause 101. When a group of 5 or more, so the minimum is 5 plus, acting in concert, which means they're all together, acting as one, commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other reason, each member of such group shall be punished with death or with imprisonment for life. So now you have clause 2 of 101, which says if 5 or more people have assaulted a human being and that human being has died, and that assault is for the reasons that are mentioned, that each of them would be guilty of murder and can be punished under clause 101, subclause 2, for the offense of murder. So you have mob lynching being recognized as murder, and that is something new. Earlier, the prosecution would have to incorporate a few sections to say, well, this is a mob, they had a common intention, and so on and so forth. The problem here is it leaves out some ambiguity. And what is that ambiguity? The moment you have, the offense is if there is a group of 5 or more, and the expression is acting in concert. So if 2 of the 5, if 2 of those 6 or 2 of 5 plus say that, well, we were told that we were going to meet Mr. A, we never knew that he is going to be assaulted, then of course that will be their defense. For a conviction under 1012, the prosecution would still have to establish that they were acting in concert, meaning thereby all of them had gathered to assault this person so as to kill him or her. Personal belief, sir, is not ambiguous. It could be related to, let's go delve into a recent history. It could be related to my culinary preferences. I eat something, I don't eat something. That doesn't give anybody else a right to kill me. You may critique me, you may criticize me, you may not agree with me, but you can't kill me for it. So personal belief is also not an ambiguity. The ambiguity is or any other ground. Now, how do you define what could be the other ground for someone to be prosecuted under 1012? That leaves a large canvas out and open for a prosecuting agency to invoke at will 1012 and say, well, this is the other ground for which I'm charging all of them with murder. That other ground would not be a ground related to race, caste, community, sex, place of birth, language, personal belief. It could be any other ground. According to me, this needs to be debated. Maybe the committee would give its opinion, it would give its observations, and maybe while this section is being debated in the parliament, they may want to curtail or define at least and define this term or any other ground. Equally important, it leaves out on the basis of religion. It leaves out that the basis of charging or death or causing death on the basis of religion. But possibly, as a student of law, I would say that religion could be covered by the expression or any other ground. That could be a possible interpretation. Nevertheless, there is some ambiguity here which I feel the parliamentarians must look at, so that in future this Sanhita, which is an extremely important thought in reforming the criminal justice system, is not abused in future.